Starting out today, we've got some news we were waiting for in this YNW Melly trial. As y'all know, we reviewed last week what was going on in court. The judge, Judge Fiend seems like he's pretty fair when it comes to getting what he needs from both sides. We were waiting to find out if the search warrant for Raven Liberty was going to be shown to the defense. And the judge was like, hey, you guys need to supply this, saying that to the prosecution. The prosecution said, Judge, I don't think we have to give that to you. Judge Fiend said, okay, cool. That's fine. You don't think that? I don't care. You need to provide it. So the state has finally responded. And here's what they're saying about that search warrant for Raven Liberty's phone. What are they saying? An ordered search warrant on YNW Melly's attorney, Raven Liberty, was not provided to the court yesterday. And we found this out late yesterday afternoon. The state argues that Raven Liberty faces an actual conflict of interest due to the allegations of her criminal conduct, which potentially violates ethical standards and impairs her ability to provide effective counsel. Well, I see what the state is saying, but that's not up to them for them to decide. That is up to YNW Melly to decide. We talked about this last week when we covered it live. The judge made it very clear that the reason they're getting this information, or the defense is getting this information, is so YNW Melly can decide for himself whether he wants to keep Raven Liberty or whether he wants to seek new legal representation. And that goes for everybody on this case. Raven Liberty, the current lead attorney in this trial. So that's up to YNW Melly to decide, not the state. So we're actually going to look at what the state says they're trying to do. And also shout out to Melly Daily. I know we've got another amazing account to follow over on X. Y'all make sure you go check out Melly Daily. But here's what they're saying in the state's memorandum of law regarding the attorney conflict. All right. So we've got Jamel Demons. Y'all know that's YNW Melly versus the state of Florida. What is the state saying? Comes now. The state of Florida, by and through the undersigned assistant state attorney, and submits this memorandum of law regarding attorney conflict and comments as follows. On December 27, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18, 2024 by Apple that on December 13th, so 5 days before, her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. So she had no idea. They didn't tell her that she was under investigation. She did not know what was going on until Apple said, hey, Raven, the police are looking at your account. You might want to look into that. Which is wild, but happens all the time. Monday, January 6th, this honorable court heard the defendant's motion. In addition, on January 6th, the state filed a motion for rehearing / reconsideration of the defendant's or tenant's motion to compel disclosure of the Apple search warrant related to the attorney Raven Liberty. Within this motion, in paragraph 11, the state mentions that regardless of the details of the investigation, Miss Liberty has an ethical obligation to withdraw even if the defendant were to waive the conflict. It's understandable. Again, it's not y'all's decision. It's not up to you. It's up to YNW Melly. And it's up to Raven Liberty, really. And then they cite the U.S. versus Pisa? Pisonia. All right. And they said the court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified, notwithstanding the defendant's desire to waive. Let's be real. This is a super weak argument by the state, because again, how is the defense going to know if the conflict is severe if they don't have the search warrant? If they don't know why they were looking into Raven Liberty? It could be because maybe they were trying to get her location from Apple to see if she was jaywalking that day, or it could be because maybe she was involved in something more serious. They have no idea. We don't know how severe the conflict is, and we won't know until we know why there was a search warrant. Otherwise, Melly's probably going to say, hey, I'm just going to keep her. She's been here the whole time. What do I need to get rid of her for? If the activity for which the attorney is investigated is substantially related to the charges against the defendant, disqualification is necessary notwithstanding the defendant's waiver. So basically they're saying, hey, judge, take our word for it. She needs to go. Hey, Melly, you should probably get rid of her. On Tuesday, January 7th, 2025, this honorable court entered a written order ordering the state to provide a copy of the search warrant to the defendant to determine his potential conflict over the state's objection. Over the defendant's objection, the honorable court ruled it would review the search warrant in camera for potential redactions. And we saw that live. If y'all missed the video, make sure you go watch it on the channel. I'll have it linked in the description too. During this January 7th, 2025 hearing, the honorable court spoke to the defendant about how it was his decision and that his decision alone to determine whether to keep Miss Liberty as his counsel despite his conflict. It is not the defendant's decision. It is not the defendant's decision, says the state. How? The United States Supreme Court has recognized that the Sixth Amendment right to counsel is circumscribed in certain situations. All right. And they're going to say Wheat versus U.S. What happened? Explaining the Sixth Amendment right to counsel is premised on the right that a defendant is entitled to receive a fair trial through the adversarial process. And the relationship between counsel and the defendant must give way to that right. And Brian Steele, I think, talked about this too when he was going to be held in contempt by Judge Glanville, saying, hey, judge, like, you're taking away this man's right to counsel. He wants me to be his lawyer. And you're saying, sorry, thug, I'm putting your lawyer in jail. He can't represent you. And that's wrong. And the Georgia Supreme Court agreed with Brian Steele in that case, which is why one of the reasons that he didn't have to go to jail. It is not the defendant's decision. Read that already. The United States Supreme Court also explicitly rejects the argument that a waiver of the conflict cures a violation of the Sixth Amendment. To the contrary, courts have a legitimate interest in ensuring the criminal trial is conducted within the ethical standards of the profession. Wheat says at 161. Therefore, the rules of professional conduct, including those rules of the State Bar Association, which govern an attorney's conduct, are of paramount importance and should assist in informing the judiciary about how to proceed. An issue here is the alleged criminal conduct involving rape and liberty. We don't know what that is. One of Demon's four attorneys clearly, after reviewing the search warrant in camera, there can be no doubt that an actual conflict is present squarely involving the personal self-interest of Miss Liberty. Moreover, this alleged conduct, if true, involves multiple violations of rules regulating the Florida bar. See the Florida bar versus Rod. And they say listing numerous rules involving dishonesty and criminal conduct as examples of unethical conduct prohibited by the Florida bar. The 4th District Court of Appeals has also recognized the superior authority and insight inherent in the trial court's purview, to reject a waiver of conflict. Okay, and they cite more case law there. And then the court's authority to reject the defendant's waiver of attorney conflict based on the counsel's prior representation of the state's witness. In fact, the 4th noted in a footnote that if a lawyer's conflict encompass counsel's self-interest, a waiver is precluded as a matter of law. So basically, the state is really trying to get Raven Liberty off of this case. It makes you wonder why in this instance, but it seems like they're putting a lot of effort into saying she needs, not only are we going to move forward with this investigation, but she needs to be removed as his counsel, which is a wild thing to say. We'll have to see how Judge Feem rules on this because it seems like their case is kind of weak. And then they cite the United States versus Fulton, not Fulton County, where the conflict involved allegations of criminal conduct by the defendant's lawyer, regardless of whether the lawyer is ultimately found innocent. In Fulton, the court stated, second, even if the attorney is demonstrably innocent and the government witnesses' allegations are plainly false, the defense is impaired because the vital cross-examination becomes unavailable to the defendant. What? So you're telling me they can bring up false allegations and get someone's lawyer removed? I usually don't go back and look at case law, but I would have to see what happened in this case because that's kind of crazy. Ordinarily, a witness's blatantly false allegations provide a rich source of cross-examination designed to cast doubt on the witness's credibility. But when the allegations are against the defendant's attorney, the source cannot be tapped. Interesting. The trial court is obligated to protect the truth-seeking function of the proceedings by considering the defendant has effective counsel, even where the defendant wishes to waive conflict. But what if they want to represent themselves? And how would that work? I guess the law is weird. Anyway, wherefore, the state hereby submits this memorandum of law to consider regarding the attorney conflict. So what do y'all think the judge is going to say on this one? Judge Fiend seems like he's no nonsense. Obviously, he's reviewing the warrant right now. He had a couple of cases that were starting this week. So I'll be interested to see what y'all think about his decision on this, because in my opinion, it's a weak case from the state. And at the end of the day, like the judge already stated, it is up to Melly to decide if he wants to keep his counsel or not. Let me know what y'all think in the comments and in the chat.